Good evening, everyone, and thank you for joining us tonight for your Know Your Rights Town Hall. My name is Nergis, and I serve as Chief of Staff for Senator Dr. Aisha Wahab. Tonight's event is about helping our community understand their rights and where to go to for support and resources. It's my pleasure to introduce State Senator Dr. Aisha Wahab. She is a leading voice for protecting vulnerable communities and making sure every voice is heard. So please welcome me in joining State Senator Dr. Aisha Wahab.
Thank you, Nergis. First and foremost, I just want to thank everybody for being here. I know that right now is a little bit of a difficult time. We are seeing a lot of concerns regarding immigration for not only, full American citizens, naturalized citizens, green card holders, visa holders, as well as even tourists, migrants, and much more. And I will say that this is a very difficult time because there is very little that as a state policymaker, we have a lot of say in, right? We don't. Immigration is largely a federal issue. However, I wanted to host these town halls and a lot of the conversations we're having about immigrant rights because our district is so diverse and just the immigrant community is the backbone of California, is the backbone of the United States. And so I believe it's important to be able to have these discussions as well as provide any resources that our office can provide and organize these types of events. I will say that very early on, we actually hosted an immigration fair that allowed for a lot of pro bono work done by immigration attorneys to help a significant portion of our district. I will say literally hundreds of people have really benefited from some of these efforts that we try to put on. And, we will continue to do as much as we can to provide as much as we can to our residents, their families, whether it's informational or it's actual assistance of some way. So I just wanted to highlight that. I am State Senator Dr. Aisha Wahab. I represent from Hayward down into San Jose, Sunnyvale, Santa Clara, Milpitas, Fremont, Newark, Union City, and the unincorporated areas of both Alameda County and Santa Clara County. And so as we are approaching 4th of July, I will say that I also want to caution everybody when they are in large group settings, when they are out in the public, and when they have a status that will be in question. From what we understand, those that actually have some type of legal status are actually in more jeopardy than some of the folks that have no paperwork. And that is a sad truth and sad reality. I also want to say that, the community is facing a lot of uncertainty, and understanding your rights is not just empowering those individuals, but it's also essential to protecting people and your loved ones. So I want to extend a heartfelt thank you to the organizations, and those organizations are the ACLU of Northern California, Central Legal de la Raza, Oakland Privacy, and the Immigrant Legal Resource Center. The work that they do varies significantly, but it will provide you with the tools that you may need or your loved one may need. And so I want you all to just, be able to ask the questions you guys have in the chat. We will be responding to pretty much everything as best as possible. We are providing interpretation services. If you have questions, we will be also providing a follow-up via email to contact information of these organizations. If there was a presentation that you liked very much and, spoke to you in some way and you need some other issues addressed, we're going to try to provide contact information so you guys can connect outside of this town hall. And so with that, I really do just want to thank all of the organizations for, working with our team. I want to thank my team. This is a very important issue directly for my team, and the residents that are here that want to just learn more and help others. So with that said, I will let you guys actually get the information needed. So thank you so much, and let's get started.
Thank you so much, Senator Wahab.
For our first presenter, we will have the American Civil Liberties Union, who will be presenting. Luis Ojeda will be doing the presentation, and translating for Luis will be Andrea Rocha. Thank you so much.
Thank you so much, Astrid, and thank you so much to Senator Wahab for inviting us and having us here to talk about such important issues. And definitely want to recognize this moment where there's a lot of things happening all across the state and all across the country that are indeed very troubling. But again, we're gathered here today to learn about some rights, learn about some information, and hopefully get the information that you all need today in order to be able to be prepared for whatever may come for our community. So my name is Luis Ojeda, my pronouns are he, him, and I'm the organizing manager at the ACLU of Northern California. So very excited to be here. I'm going to start with a quick roundup of some policy updates that we want to share with folks. And then we'll run into a quick Know Your Rights training. I know that there's going to be lots of different questions and lots of different specific examples of situations or things that folks may want to discuss. And so we'll do our best to answer questions, but definitely want to provide as much of an overview of the situation as we can, and again, get you all prepared. So first wanted to start with just sharing a lot that's been going on as it relates to TPS, temporary protection status. So since taking office, the Trump administration has made multiple efforts to end temporary protection status for various countries. As folks may have seen back in January, former President Biden extended TPS for 18 months for several countries, including El Salvador, Sudan, Ukraine, and Venezuela, prior to his departure from office. But obviously, once Trump took office, there was an effort to get rid of TPS for a lot of different countries. And so here on this slide, you can see a list of various countries who currently have TPS protections, as well as the current tentative end dates. And then those that are have a little asterisk next to them essentially note that there's current litigation or challenges that are happening in relation to that protection. So specifically, for example, on May 19th, the U.S. Supreme Court revoked the preliminary protection that the district court had that a district court, excuse me, had previously granted, and so as a result, the Trump administration was allowed to implement the termination of Venezuela's 2023 TPS designation for about 350,000 Venezuelans. So again, it was a very disappointing decision by the Supreme Court, and obviously very concerning in terms of how that's going to play out in our communities. How it's going to impact folks on the ground. But there was some good news, as folks I'm sure heard earlier this week. The Trump administration announced that he was going to be trying to end TPS for Haiti for about 500,000 people. But yesterday, a federal judge blocked Trump's recent announcement. And so obviously this is still going through the court process. And so it will be, we'll have to see how that plays out. But again, at every moment where Trump is trying to do something, there are legal challenges and efforts that are happening in order to put a stop, or at least to delay those attempts. And then just also wanted to note that there are also additional ongoing cases challenging the Trump administration's attempts to end TPS for Afghanistan as well as Cameroon. And so again, this has just been a priority for the Trump administration in terms of trying to strip legal status away from people, from immigrants from various countries and from different places. But again, there is a coordinated and strong effort to mount legal challenges and to try and put a stop to these attempts to end TPS. But again, it is important for folks to note the impact that this is going to have on folks. So if you yourself have TPS, or if you know someone who has TPS, it's going to be really important for you to pay attention to those ever-changing circumstances as it relates to TPS, and to make sure that you are seeking legal guidance and support in the event that, again, you or someone you know is directly impacted. Additionally, also wanted to give an update and share a little bit about what's going on with the attempts by the Trump administration to end asylum. And so obviously, since taking office, one of the Trump administration's priorities has been to try and end asylum and access to the asylum system for anyone. So he's attempted to shut down the process. But today, we actually did get a good ruling from a federal judge who blocked the Trump administration's attempt to limit asylum. The court rejected the administration's effort to use a 212F proclamation, which falsely cited an invasion as justification to deny asylum protections expressly granted by Congress and summarily deport families and individuals to countries where they are at grave risk of persecution with no recourse. The administration was granted 2 weeks to appeal the case, and so obviously this is going to be a continuing issue. But obviously this is good news, again, in terms of bad policies that the Trump administration is trying to implement, but again, continuing to face challenges in the courts to slow and push back on those issues. And so I've linked here that you can read more about the case. But again, we have obviously seen a significant decline of folks being able to access asylum, refugees being denied access. And so obviously that's incredibly concerning and obviously not what we want to see. But again, a lot of the cases are ongoing and there's a lot of challenges that are happening to make sure that those things don't happen. Another thing we wanted to note as well was to talk a little bit about H-1B visas. So these are work visas for foreign workers and specialty occupations, and wanted to sort of highlight this overall trend in terms of numbers. So the current application period for this fiscal year, which is 2026, you can see that there's been a significant decline in the number of folks who have applied for H-1B visas. And so again, there's this continuing and growing fear amongst immigrants and amongst employers around applying or getting involved with H-1B visas. And so I think there's a lot of different reasons that we can sort of explain this significant drop in numbers, over 100,000 less registrations. But we do know also that the Trump administration has spoken about scrutinizing applications more closely and really being more mindful of all of those different issues. But I do also want to plug a program from through the Cornell Law School, excuse me, Path to Papers, which does support folks who are interested in learning more, excuse me, about the H-1B visa process. And so I want to encourage folks, if that's something that folks are interested in looking into or wanting to learn more information, there is a lot of resources that the program has, particularly in the Bay Area, in terms of supporting people and walking them through those processes. But again, lots of things are ever changing, and so we want to make sure to encourage folks to be on the lookout for those changes as they occur. All right, so now I'm going to walk through several slides around knowing your rights. I want to make sure to flag all of these issues that as they're happening to make sure that you know your rights and that you're better prepared in the event of any ICE activity. So a few things before we start. I do want to note that it's important to say that immigration agents may violate your rights and lie to you, as what we've seen in Southern California with the massive immigration activities. There's been a lot of activity and actions done by immigration agents and other immigration enforcement staff that I think are extremely frightening, and I think go against a lot of the things that we're sort of used to seeing in the past in terms of their behavior and the way that they're approaching their actions and the things that they're doing in the community. But regardless, it is important for everyone to stay calm, not to run, argue, resist, or obstruct officers when you do encounter those situations. And even if you feel like your rights are being violated, because again, the consequences of fighting back or doing anything that would constitute as resisting or hurting an officer or anything like that, the consequences could be even more severe in terms of exacerbating the situation. So important to keep your hands where police can see them as well. And then also not to lie about your status or provide any false documents, I think is also really important for everyone to know. One thing I also did want to flag is that in this moment, I think there's a lot of fear, again, and uncertainty in our community, and a lot of folks are seeing unmarked vehicles or suspicious looking vehicles and sort of making assumptions about them being ICE. And sometimes that may be the case. It may be that they are ICE vehicles and that there may be ICE activity happening. But want to encourage folks to get familiar with the various different vehicles that are law enforcement in your community. So here are sort of some examples of some more obvious CBP and immigration vehicles. But obviously there are also other local CHP and other federal and state agencies that have vehicles that obviously are law enforcement vehicles, but aren't necessarily ICE. But obviously what we are seeing more of is these sort of unmarked vehicles with the tinted windows. Generally, they're American brand vehicles such as Ford, Chevy, GMC, or Dodge, and they have often these sort of police lights that are sort of in the front of the vehicle. But again, lots of different law enforcement use these vehicles as well in terms of cars that are unmarked or have tinted windows or vehicles that look very much like this. And so again, I think in this moment, it's important for us not to create panic and fear in our communities, but to really be vigilant and be on the lookout for these types of things, vehicles in the community, and to be able to verify and cause not cause panic, but really be able to identify potential ICE vehicles. So just wanted to also just make a note of that as we're thinking about immigration in our community. Some other few points that we want to highlight as well is just making sure that you're preparing with your family and friends. Obviously, what is happening in LA and Southern California is deeply concerning and frightening. And so I think that we should not assume that that won't happen here. And so I think folks really should be having hard conversations and difficult conversations with their family, loved ones, and friends in terms of having a plan, knowing what to do in various different settings and situations that you may find yourself in. And always remembering to assert your right to remain silent. And this doesn't just mean to remain silent, but to actually assert it and to say that I'm asserting your right to remain silent. That is an important component as well. And then at any time that you are that you do come into contact with law enforcement or ICE, you can always ask if you are free to leave. Again, as just a way to communicate that you're not interested in speaking with them. And then as usual, you should always refuse to sign anything until you speak with a lawyer. And so anytime anybody is giving you anything to sign, we generally recommend that you don't sign it until you speak with a lawyer in the event that that may have some consequences in terms of your individual case or situation. A couple of other things to note, obviously right now with all of the different ICE activity that is happening, a lot of this may not be, this isn't as relevant because for the most part, ICE is sort of approaching folks and taking people and isn't offering a warrant. But in the event that you do end up being in a situation where ICE has a warrant, it is important to note the difference between a judicial warrant here on the right, which is a legal warrant that has merit, that is signed by a judge and has a date, has your name, has information about you or anything like that, as opposed to a nice administrative warrant, which is just a piece of paper that ICE puts together that again is meant to mimic what a judicial warrant is, but does not have the same legal standing as a judicial warrant. And so oftentimes ICE will attempt to use these ICE arrest warrants and claim that they are the same as a judicial warrant, but these are not as valid, and you shouldn't treat them in that way. As you can see, they're often not signed by a judge, and this is just them putting together their own piece of paper saying that they're looking for somebody. And so, again, it's important for you to know the difference in the event that you encounter these types of situations where they're presenting you with some sort of paperwork and being able to tell the difference between the two. I think I'll go through these sort of different scenarios relatively quickly. But one of the things that we have often seen, obviously, is ICE being at people's homes and go into people's homes. And I think there's sort of been a decrease in that in a lot of ways, but I think, that is definitely still a tactic that they use. And so again, it's important for folks to remember not to open the door when folks knock, and to have that conversation with everyone in your family, right? So some child or someone else in the home isn't sort of just randomly opening doors for strangers, to really make sure that we're being cautious. And again, in the event that it is ICE activity, to make sure that you're reviewing that warrant, not face to face, but ideally through a window, a peephole, camera under the door, etc. And again, verifying whether that warrant is valid, whether the person that they're looking for is actually there or that lives in the home, and making sure that you're proceeding with caution in any of the situations. But again, important, even under these situations where you're going to be under severe stress and it's going to be very frightening, to not resist in the event that ICE does force their way in. And again, invoking your right to remain silent, and saying that you want to speak to a lawyer, and not signing any documents. And I think this is very similar to if you encounter ICE on the street. Obviously, we've seen this happen a lot where folks are being picked up in parking lots or car washes or just out and about, maybe a street vendor, for example. And so it is important for folks to remain calm, to not run, and to not give ICE any reason to arrest you. You do not have to answer any questions about where you were born. And so again, asserting your right to remain silent, and asking if you're free to go. Again, this is all sort of guidance for how you should respond, but obviously when you're in that situation, there may be circumstances that make this very difficult to remember. You may not remember those things, but I think it's important to remember sort of these two at the bottom in terms of asking if you're free to go, and remaining silent, and saying that you don't want to speak to them and you don't want to sign anything. Additionally, at work, obviously there's sort of, it's a different situation there. It is important to note that with businesses and businesses, there is sort of a difference between where ICE can go. They are able to go in any location that's sort of open to the public. And so, for example, if you work at a restaurant, the dining area or the waiting area anywhere in terms of a restaurant where the public has access to is a place where ICE is able to go into. So I think it's really important for you to have a conversation, encourage your boss or other coworkers to have a plan in terms of what you would do in the event of ICE being in your at your work or at your place of business, and again reminding people of their rights to remain silent, and not sign anything, and just sort of being on the same page. And I'll link here for folks that a guide that NILC put together for employers in terms of what to do if immigration comes to your workplace. But again, it's about being prepared, having conversations with your coworkers, with your boss, to make sure that you know what to do in the event of ICE coming into your business or work. Really quickly, there's been a lot of conversations around sensitive locations. So this was previous guidance that is no longer valid. In the past, there was sort of an effort by ICE and immigration to limit their participation or their activity, in schools, hospitals, and places of worship, as well as courthouses. But that's no longer the case. And what we are seeing is more activity happening at courthouses and other places where we previously weren't seeing immigration. So it is really important for folks to just be mindful and again, think about those sort of different scenarios and be prepared for how to respond to them. So in terms of schools, we want to note that public schools are prohibited from asking students or their parents about their immigration status for the purposes of enrollment. And so, it is important for folks to just think about what information we're sharing with our schools. And then they also aren't allowed to reveal students or parents' immigration status without their permission. And they shouldn't be requiring social security numbers for students in terms of enrollment as well. But I think it is, again, important to think about the data that we're sharing with schools and making sure, again, that your school is prepared for these situations. But again, they have the ability to prevent schools from entering private areas for the school. I shouldn't be allowed to sort of go in and roam freely. Schools should have a plan in terms of, again, being presented with a warrant, having the name, notifying parents, having the superintendent involved or other legal counsel for the school to be able to review the warrant and sort of respond in the most appropriate way. But either way, and regardless of all of this, students do have the right to enroll and attend public K-12 schools. And so again, we should be doing everything we can to make sure that students feel safe at school. But again, in the worst case scenario, something happening in school, for folks having a plan and being prepared in terms of making sure that the school knows who to notify in the event of something happening, or if a parent is picked up or anything like that, to just sort of have a plan in place. And then again, similarly to businesses in terms of places of worship, again, they're not required to and cannot be forced to enforce immigration laws. But again, ICE agents do have the ability to enter public spaces of a church or other places of worship without a warrant, but again, not private areas. So it is really important for any businesses or places of worship or clinics or anything like that to make sure that they're making very obvious distinctions in terms of what is a private area and what is a public area, because again, generally speaking, I shouldn't be entering those private spaces. But again, lots of different considerations here, and we'll share some different resources for that as well. Another thing I wanted to know is just it's really important for folks to record and take pictures as much as possible. Obviously, in these situations, it can be very intimidating and very scary to be confronted by ICE or be in a situation where ICE is there in the community. But as much as possible, and if people feel comfortable, we want to encourage folks to record, take pictures, make a note of what they're wearing, what kind of cars they're driving, who they're picking up, and all of that, because all of that can be very helpful in terms of being able to share with rapid response hotlines and other networks to then support folks who are being impacted by immigration. And so I know we're going to plug this a little bit at the end, but also wanted to just mention the rapid response networks in Alameda and Santa Clara County. Again, share the numbers and their websites, as well as other rapid response networks if you're joining from other places. Again, I'll share these links in the chat momentarily, but again, also wanted to share these different resources. The Attorney General also has some model policies that we can monitor in terms of school policies and other things like that. And then again, we have some guidance documents for schools, places of worship, and health centers as well that you can take a look at and kind of assess whether you think any of the places that you frequent could use some refresher in terms of their rights and what information they should be aware of. And so with that, we'll, I think, open it up for Q&A. And I'll also move to the slide that has my email, as well as, again, a link to our legal intake hotline. And so if you think your rights have been violated, or if you have a legal issue you want to flag for us, you can always go to this website and submit a legal intake, or you can call our legal hotline as well. And again, the number is there, 10 a.m. to noon, 1 to 3, Monday through Friday, if you want to flag things for us.
Thank you so much, Luis. We do have a question in the chat from one of the attendees. They're asking, are you able to share what our rights are with airport security? For example, if we are asked to turn over our phones without any reason, are we required to do so?
Great question. I think there might be a presenter after me that might answer this question or get into that. So maybe we can sort of save that for later in case there isn't a response to it. But definitely important for folks to take necessary precautions in those situations for sure.
Awesome. Thank you so much, Grace. I also do want to remind everybody who is on. I do see a raised hand from Siegfried. If you do have a question, we ask you to please put it into the Q&A section. So then we can have the presenters answer those questions live, or you can send me a private message and I'm happy to answer your question. If anybody has any further questions for Luis, please put them in the chat. If not, then we are going to say thank you so much to Luis and to ACLU for being with us once again. This is the second time that you have supported one of our events. We are so happy and grateful to have you here sharing the important information that our community needs. I will also, between speakers, review the information on how to access the Spanish interpreting channel. So I will do that right now. And I will follow the information that I say in, I will say it in English and then I'm gonna say it in Spanish. Hold on, I think we do have more questions. Nergis, do you want to unmute and ask the question?
Sure. Luis, if you're still there, I believe there's two questions that we just got in the chat. The first one is, I applied for a TPS renewal 4 months ago and my case is still not approved. Do you have any information if TPS is in jeopardy of it being jeopardy of its renewing applications?
Yeah, I think that's going to be very specific to your own situation in terms of what country you have submitted this renewal for. So I would recommend you, if you worked with a lawyer, to make sure to connect with them for an update, and if not, to reach out to a community organization or group that is supporting folks with renewals and other immigration services.
And then the other question is, what's the best way to help ACLU? Donate, volunteer, could you provide a link for NorCal ACLU page? Thank you.
Definitely, yes. You can always go to aclu.org if you're interested in making any donation. And then for Northern California, it's just ACLU-NC, northern-california.org, and you can find different information and ways to get involved by visiting us there.
Thank you, Lee. And for a friendly reminder for everybody, if you do have a question, please use the question and answer chat. That's the best way to get your answers. If you're raising your hand, it's kind of hard to get to you. So feel free to just put your question in the question and answer chat.
You are also able to submit questions anonymously if you don't want information. Luis, I did want to follow up on the first question regarding TPS. I think you did touch on that during your presentation, specifically for countries like El Salvador. Did you have a status update on that?
Yes, I think for El Salvador, as far as I'm aware, that is still set to expire next year. And so there is still time there. But again, even with the attempt to end TPS for Haiti, that just happened this week. There's sort of many attempts to end TPS programs. And so again, it's going to be really important for folks to pay attention, talk to your lawyer if you're in that, if you work with the lawyer with your case, to make sure that you're up to date in terms of the latest, because this is really changing on a week-to-week basis.
Awesome. Thank you so much for that information. We do see a couple of hands that are raised. So Parwana and Siegfried, if you do have a question, please, I encourage you to enter your question in the Q&A so then we can answer your question live. So I will repeat the instructions on how to access the Spanish channel. To hear the presentation in Spanish, please click the globe icon at the bottom of the Zoom screen and select Spanish. If you are on a phone or tablet, tap the 3 dots that say more and then tap language interpretation to choose Spanish. I will repeat this in Spanish. Para escuchar la presentación en español, por favor, haga clic en el icono de globo en la parte inferior de la pantalla de Zoom y seleccione el idioma español. Si están usando un teléfono o una tableta, toquen los 3 puntos que digan más y luego seleccione interpretación de idioma para elegir español. If anybody has any questions on how to do this, you can send me a message directly. Si alguien tiene alguna pregunta cómo acceder el canal de español, me pueden mandar un mensaje directamente y yo le puedo ayudar. For our next presenter, we actually are really excited to have Centro Legal de la Raza, they are, located here in the East Bay, and they provide a lot of great services. And presenting for them is Alyosha Magan, and he is a Equal Justice Works Fellow and an attorney. And translating for Alyosha is our very own Barbara Ledesma-Reinhardt. Thank you so much, folks.
Thank you, Astrid, and Centro Legal de la Raza and I would personally like to thank Senator Wahab for inviting Centro Legal de la Raza to be able to present two very important topics this evening for everybody about the rights that individuals and families have after they are arrested or while in detention. And in the second part of my presentation, we'll focus on the rights of property owners when immigration officials come looking for their employees. Once again, my name is Alyosha Mahin. I'm an immigration attorney and Equal Justice Works Fellow with Centro Legal de la Raza. Could I have the next slide, please? I can also share my screen. Thank you so much. Did want to say just very briefly a little bit about what Centro Legal de la Raza is all about. We were founded in 1969, and we provide legal services throughout Oakland, throughout the various counties in Alameda, and we're based in the Fruitvale district. Fruitvale truly is ground zero for immigrants' rights issues. We have an intersection of communities from various income backgrounds, communities of color who all live and work and come through the area. Our organization works to protect and advance the rights of these low-income communities, primarily in the Alameda and Contra Costa counties, through legal representation, education, and advocacy. Our legal services programs provide services with immigration and tenancy issues while also hosting a Youth Law Academy. The Youth Law Academy caters particularly to underrepresented populations who are not represented in the legal field. Many of these students go on to legal careers and to law school after completing the Youth Law Academy with us. Next slide, please. I'm seeing a message that's saying that people cannot hear me. Is that the case? Could I get verbal confirmation, please?
I can hear you.
Okay, thank you so much. So we're going to get into the first part of the presentation, post-detention rights of individuals and their families. All this essentially means is that people do have rights upon being arrested and after being placed into detention. And I'll briefly go through what can seem like a vast amount of rights. What I'm going to present is not an exhaustive list, but certainly a lot of things that people need to be aware of and think about when they are arrested and when they are detained. Next slide, please. So like my colleague from the ACLU mentioned, if you are detained, you do have rights. One of those is the right to remain silent, not answering questions about your country of origin, not signing any documents without consulting with a lawyer, not answering questions about your case without consulting with a lawyer, having a lawyer present. However, there may be certain situations during the arrest or during the detention period where you may wish to suspend silence. Next slide, please. It is critical to suspend silence, especially in the situation where you want to consult with the lawyer, either by phone, by video, or in person. Note that the government of the United States is not required to provide a lawyer for you, but nevertheless, the option is there to have free phone calls placed to communicate with a lawyer or with a legal aid organization to secure your initial representation. They are required to give you these free phone calls when you are in detention or upon being arrested. A lot of times in the detention centers as well, there is the ability to provide free or low-cost resources for people to get in touch with lawyers in their immediate area or throughout the county that they are in. You also have a right within a detention setting, to receive visits from a lawyer. Some detention centers even, including one near Bakersfield called Golden State Annex, provides Know Your Rights sessions in conjunction with other legal aid organizations to orient folks about their legal rights in detention and to guide folks on a somewhat limited basis as to what their options are in their specific immigration situations. Another quick resource that I'm going to share that I'm also going to be speaking about throughout the presentation is called the ASILIP Network. That stands for Alameda County Immigration, Legal, and Education Partnership. Very briefly, and I'll touch more upon this throughout the presentation, what ASILIP can do for folks upon being arrested is to dispatch an attorney on a limited scope emergency basis to try to advocate for the release of that person. During detention, what ASILIP can do is provide a limited scope legal consultation about the rights and the various legal options a person has in detention. The phone number is right there, 510-241-4011. It's very important to put that phone number into your phones right this moment. You'll see it also at the bottom corner of the presentation that I'm giving right now. It's very important to have that on your phone, and it's very important that if you find yourself arrested or in a situation where you are detained, to have that phone number actually memorized. Next slide, please. Likewise, a second right you have in detention is to have communication and to receive visits from your family. You can place initial phone calls to family and receive phone calls from family to be able to get access to legal resources. After that period, however, usually the phone calls are not free and they require family to pay into accounts such as gettingout.com, CorrectPay, JPay, all depending on the detention facility. It's basically commissary accounts that the detention sites have for folks to be able to place phone calls to their loved ones. But that aside, the right that folks have in detention is to be able to communicate with and receive visits from family. I'll go into this more as it relates to family members trying to communicate with loved ones later on in the presentation. Another right that folks have is to be able to obtain medical care while in detention. While being far from perfect, the medical care that one can receive really can help in terms of managing symptoms and helping to put off any sort of deterioration of one's own medical condition. So I've spoken with folks in different detention settings who have gotten access to treatment for their eyes, for diabetes, for cardiac and vascular care. Again, far from perfect, but this is a right that you do have if you are in a detention setting to be able to obtain medical care, to be able to manage your symptoms in that setting. Next slide, please. If you are detained, another right you have is to contact the consulate from your country of origin, or to have a detention officer even make that contact for the consulate on your behalf while you are in detention. Consular officers, I don't think it's very well known, but what they can help you do while in detention is help with obtaining legal representation, acquiring medical care, communicating with family members or loved ones, or even providing necessary items that you may need for daily living. So again, if you do know or have access to be able to call your consulate, if you know those phone numbers, it's important to begin to put those numbers on your phone and also to begin to memorize that information for yourself. Next slide, please. Now we're going to get into a little bit in the weeds in terms of specific immigration scenarios. But one thing that folks can do in a detention setting is to inquire about and obtain release options. Now, this is going to depend on a number of factors in a person's specific immigration situation, including if this is the first time a person is in the country, if they're in removal proceedings already, or if they have criminal history or convictions and prior immigration violations. That being said, it's still worth asking an ICE official, or if you are going before an immigration judge while being detained, it's worth asking if you can be released on your own recognizance, which is basically a fancy way of saying if you can be released on your own free will, or by paying bond. ICE or an immigration judge have discretion, which means they can make an independent determination in your case based on a number of factors as to whether you can be released on your own recognizance or be released upon paying bond. These factors, not an exhaustive list, but include whether or not you are a danger to the community, if you're likely to attend your future court hearings, if you have ties to the community, if you live with family members who have lawful status, such as legal permanent residents or are United States citizens, the length of time you've spent in the United States, and of course, very relevant would be your criminal history or prior immigration violations. Be prepared to demonstrate positive factors in your case when speaking to ICE or an immigration judge when trying to vouch if you want to be released on your own recognizance or released upon paying bond. A lot of times as well, it is helpful to try to produce documents. Now, I will say that it is very hard to keep your own documents ready to be able to present to ICE or to an immigration court while in detention. But this is where family and having the attorney really play a crucial part to be able to help people have access to these documents and to be able to present them on a detained person's behalf. So documents that highlight the positive aspects of the way that you have been living in the United States, the positive equities that I've laid out here, all of those things are important, and family and an attorney can help be able to facilitate that for you if you are in this detention situation. If that's not possible, however, convincing an official or a judge verbally or through testimony can be enough to convince them to release you on your own recognizance or upon paying a bond. Next slide, please. Relatedly, another thing worthwhile to inquire about is to see if you can be released on what's called parole. And this, I'm going to focus on the application of parole in a specific situation that may actually apply to a lot of folks in the audience right now. And I know certainly apply to a lot of folks who are in the country as non-citizens. If you've been in the country for less than 2 years and have not sought an immigration remedy, you can be released on what's called parole. And again, while that's discretionary, ICE does have the power to release people on parole. And from the statute, the language says that you can be released if you can present evidence of a serious medical condition, if you're pregnant, if you're a juvenile, if you are a witness to proceedings in the United States, or if you're an individual whose continued detention is not in the public interest. These factors, while not exhaustive, can help you be released on parole. Next slide, please. Another right that you have, and I think one that not a lot of folks know about, is to ask if you can be housed locally. Basically meaning, if you are going to be detained, can you be in a detention center as close as possible to your original place of residence? And this is particularly important where a person has retained a lawyer locally, and it's important for the facilitation of that relationship and that service that a detained person stay as close as possible to their residence, in proximity to where they're being detained. And of course, it's also important to be asked to be housed locally if there is critical or potentially life-saving evidence near your place of residence that's going to be made unnecessarily difficult to access if you're transferred far away from your place of residence or even out of state. Another right that folks have, and this right comes up if you have not been in immigration removal proceedings before. If you are afraid to return to your home country, you may have the right to ask for a credible fear interview or a reasonable fear interview. Now, depending what type of interview you get, that all depends on if you have criminal convictions or if you have prior removal orders. I won't go into the specifics of the standards of proof for these interviews, but what is important is to what is important to point out for both is that if a person has a fear of returning to their home country, they can express that fear, they can break that silence and express they are afraid to return to their country of origin, and that can give them access to either a credible fear or a reasonable fear interview. The line of questioning in both of these interviews is essentially the same, including being asked, who harmed you? Why were you harmed? What level was the government involved with trying to protect you from harm? And could you safely live in another part of your home country? Answering these questions helps to determine if there's a possibility that a detained person would be harmed if returned to their home country. And if successful during these interviews, the person would be referred to an immigration court where they would have to elaborate more on the perpetrator's harm, the reasons why it happened, the level of government involvement in protecting the individual, and being able to safely relocate in the country. The standard of proof would be higher in immigration court proceedings compared to the interview. But without getting into that, what's important to note is that this is another right that folks have in detention to avoid being deported to a country where they fear persecution, where they fear harm, and to potentially acquire an immigration remedy like asylum, like withholding of removal, which would give a person lawful status to be able to stay in the country. Next slide, please. Another right that folks have if they are facing imminent deportation, that is, a person has been issued a final order of removal and is close to being deported in a matter of days or weeks, for example. One can ask for what's called a stay of removal. It does cost a couple of $100s, a little bit more than that. And the approach would be different depending on where you find yourself. If you're trying to vouch for a stay of removal before the Department of Homeland Security, before an immigration judge, before the Board of Immigration Appeals, or before a federal court of appeals. But essentially what one would have to demonstrate is pretty much the same thing that one needs to demonstrate to try to be released under your own recognizance or try to be released by paying a bond. Those positive factors like we discussed earlier, your community or family ties, the length of time you've been in the United States, medical or psychological conditions. These are all positive factors that may be able to demonstrate that a court or an official should be able to grant you a stay of removal. While in detention, it may seem obvious, but you do have the right to fight your deportation case while in that setting. I will say that it would be likely a protracted fight and a very complex fight, and it would be critical to have an attorney to be able to guide a person in detention, to be able to provide the advice and the representation needed before the various officials and before the various actors that you would encounter in a detention setting. And of course, it's very critical to have family and community support for things ranging from mental and emotional help to financial support. And like we talked about earlier, being able to access those documents which may show that you warrant a stay of removal, to be able to be released on your own recognizance, or to be able to be released upon paying bond. Next slide, please. So if you are detained, it's important to know the basics. Basics have to do with knowing some very critical details about your own immigration case. Not many details, but it's important to recognize what those are and to begin to memorize them as soon as possible. Start to memorize the phone numbers of your loved ones with access to your immigration records. Start to memorize the phone numbers of your lawyer if you already have one, or of the ASILIP network, the 510-241-4011 number. Start to put it in your phone and start to memorize that phone number in the event you find yourself arrested or in detention. Memorize your immigration number. It's also known as the A number, and usually it starts with an A and it's followed by 9 digits in most situations. Start to also, before you find yourself arrested or in detention, to create a family preparedness plan in the event you are detained. Start to speak with your loved ones and have those not so easy conversations about who would take care of the kids, who would be able to provide money for rent in the event that the breadwinner of the household is arrested and detained, possibly deported. Start to have those conversations. Start to also have the conversations of where loved ones can go in the event that one is arrested and detained. Perhaps there are neighbors or other family in the area that you have trust in that you could stay with that could help you in the very short term, try to stay stable. Start to also write down those very important phone numbers of doctors and school teachers, make lists of medicines and different appointments one has to be able to quickly go to those very important appointments and meetings in the event that a person is detained and can't actually facilitate that for a loved one anymore. And again, understand that it's important to know you have the right to remain silent, but there may be situations where it's critical to speak up, especially when trying to get that initial representation going with a lawyer, to be able to vouch for your ability to get a credible fear or a reasonable fear interview, or to be able to obtain that critical medical care that you may need. Next slide, please. Now, for the family whose loved one is detained, you can help your loved ones in detention. You can start by calling your loved ones in detention by paying those commissary accounts that we talked about in the beginning, right there through Getting Out, Correct Pay, JPay. Understand that these calls are not confidential, so it's important to not speak about specific case details during these calls with your family members. Leave that between the lawyer and your loved one in detention. You can also visit detention centers. It's important to look up the policies of a detention center, the visiting hours of a detention center, because they're all different. And another recommendation that I like to tell folks is that a family member who has their own vulnerable immigration situation, it's advisable that they should not visit detention centers to avoid a situation where one might be arrested or run into other problems. You can send letters to your loved ones in detention. You can send items to loved ones. Again, look up the policies of the specific detention center surrounding what it takes and what you can send and not send regarding letters and items. And also, if your loved one is detained, you can also help by beginning to gather important documents and to look for a lawyer for your loved one's behalf, and then calling them to let them know that you've obtained representation for your loved one. Next slide, please. So locate family members. You can use this website, the locator.ice.gov, to be able to search for a loved one who has been detained. You can find which detention site they're being held in. Here is the front page of the website. The easiest way to find a loved one is to know their A number and to plug in their country of origin. Just those two steps usually takes you to a very small profile of your loved one and the detention center of where they're being held. If you don't know a person's A number, you can go through some additional steps there, a search through biographical information, plug in some demographic data about your loved one, and that can also take you to a small profile and show you where your loved one is being held. Next slide, please. So we just went over some rights of people when arrested or in detention. Right now, we're going to move to a second topic, rights of property owners where there is immigration enforcement at the workplace. Next slide, please. So it helps to give just a little bit of historical context, and not too far back, prior to 2017, prior to the passage of the Immigrant Worker Protection Act, federal immigration authorities could routinely inspect work sites for possible enforcement actions with or without advance notice, and employers could voluntarily allow immigration agents to access employee records and non-public areas of basically private areas of the work site. Next slide, please. But now, since 2018 and the passage in California of AB 450, the Immigrant Worker Protection Act, now the way things are is this. Other than for purposes of an I-9 inspection, which is basically an inspection to ensure that an employer is in compliance with hiring workers who have legal authorization to work in the country, aside from an I-9 inspection, an employer shall not provide voluntary consent to immigration enforcement, to ICE, to enter non-public areas of a place of labor, or to access, review, or obtain an employer's employee records, unless there is a subpoena, which is just a fancy way of saying that a court is requiring a person to present themselves as a witness or produce certain evidence, or a judicial warrant signed by a federal judge. These warrants need to be signed not by a state judge or a head of a federal agency or department, but by a federal judge by the federal judicial branch. And I'll speak more about warrants in a little bit more depth momentarily. And this rule also applies whether the employer is private as well as public. Next slide, please. I want to distinguish 3 different scenarios of where DHS may come to your workplace. One of them is this situation of the I-9 audit, which is to ensure an employer hired employees authorized to work in the country, excuse me. Usually, ICE needs to give at least 72-hour notice or 3 working days to the employer to be able to come on site and do the inspection. Union representatives and lawyers can be present during an I-9 audit. So it's important that employers understand that they have the right to have union reps and lawyers on site. Another situation where ICE may come to the workplace is during an ICE raid or the arrest or for an arrest of a particular individual. And these occur where immigration authorities do not provide warning beforehand to investigate an employer. It's important to note that when that happens, the law prohibits such an investigation without a valid judicial warrant. Next slide, please. In all of these 3 scenarios, and I'll distinguish the I-9 audit just a little bit, but in all of these 3 scenarios generally, there are Fourth Amendment protections for the place of employment and for the employer. The constitutional right to be free from unreasonable searches and seizures. ICE can only go to public spaces only, which includes, and was said from the ACLU earlier, the waiting area or lobby, dining areas in a restaurant, for example, or the parking lot of a school or a hospital. But ICE may not enter any private space or non-public area unless they have a judicial warrant or they've been granted consent by a person with authorization in that place of employment. Next slide, please. What's important to distinguish is that with the I-9 audit, it's true that they need to come on site to be able to review certain documents and to make sure an employer is in compliance. Usually those records are stored in a private space. And usually for the purposes of an I-9 audit, immigration could go into that space. But beyond that space, Immigration and Customs Enforcement, ICE, cannot go to other nearby private areas for the purposes of executing their enforcement. So that's the wrinkle with the I-9 audit. They could go to a private space where the records are held, but beyond that private space, they cannot access any other private space without a judicial warrant and without the permission of the employer. What are our recommendations? Make private spaces clearly known to Immigration and Customs Enforcement with signage. Restricted area, authorized personnel only. This space is for only employees, employees only, staff only, no access without permission. All of these things communicate to ICE very clearly, should communicate to them very clearly anyway, that they are not allowed to enter these spaces. And if they do, they are running afoul of your constitutional rights. A sign could go on the door that divides a public waiting room from other offices. That could be only accessed by employees. It should also be placed in any other smaller setting that a person wishes to designate as a safe space that can only be accessed with consent, such as a smaller office or cubicle, a consultation room or an examination room in a hospital, a classroom, or some other service area inside of the workplace. It's important to put all these signs. It may feel a little bit redundant, especially if they're in a larger private space, but still worthwhile to put these signs in those spaces as well. Next slide, please. Never, and I just want to reemphasize this, it's never try to give consent to ICE in a private space, and carefully review anything that ICE claims is a warrant, which we're going to talk about right now. Next slide, please. A valid judicial warrant looks like this. It's issued by the judicial branch. of a federal court, usually a United States District Court. It says right there at the very top, United States District Court. It specifies particular things that are or particular people even who are to be searched and seized in the body of the judicial warrant. And it's going to be signed near the bottom by a federal district court judge. It's important to note that ICE almost never has this judicial warrant. What tends to happen and what ICE tends to rely on is more verbal and psychological pressures on an employer to be able to give access to private space. And we want to make sure that you guys know that to be able to be aware that this may happen, it's important to be prepared to encounter ICE authorities in the event that they do want to coerce and put pressure on you to try to give access to your place of employment, particularly those private spaces. Next slide, please. A little bit more on warrants, and we're going to do a little compare and contrast in a moment. An administrative warrant, like the ACLU touched upon earlier, is a document from the Department of Homeland Security that does not give permission to ICE to be able to enter private spaces. Next slide, please. These are the administrative warrants. What distinguishes them from the judicial warrants, you can see at the very top on the left side, one says warrant for arrest of a non-citizen. On your right, you see one labeled U.S. Department of Homeland Security. All these administrative warrants really do is to give ICE the ability to execute an arrest in public. But just because ICE has them and is waving them around in your employment space does not give them the permission to be able to enter a private space. It's one thing that a warrant says that they can arrest a person, but it's another thing entirely to say that they can enter a private space, a constitutionally protected area, to be able to effect that arrest. Next slide, please. So if ICE comes to your work site or place of employment, and they are waving around that administrative warrant with your employee's name on it, you do not have to say if that employee is working on that day or not. You do not have to take ICE agents to that employee named on the administrative warrant, even if they're working there at that moment in time. What we advise folks to say is that this is an administrative warrant and you don't have the right to enter my employment space, the areas that are private in my employment space. Next slide, please. Now, if there is a judicial warrant, in that rare situation where there is that judicial warrant, understand that if they are able to still access a private space because they have the right warrant, constitutional rights for your employees still apply. Employees still have the same rights as was touched upon earlier by the ACLU, the right to remain silent, the right to not answer questions, particularly about their country of origin, the right to not give names, the right to be free from searches and seizures of on their person, like their pockets, their purses, their wallets, etc. You can also, as an employer, consult with an attorney before, during, and after ICE enforcement on your property. Remember, the only way that they could access those private space is if it's clearly written and clearly articulated in the body of a United States District Court judicial warrant signed by a federal district judge. Next slide, please. We're almost going to wrap up with this, with my part of the presentation. I just want to quickly give just a little bit more information about what a CLIP is. If you haven't written down that phone number, it's right there at the bottom of your screen. Next slide, please. What a CLIP can basically do for folks upon an arrest is an emergency dispatch of a lawyer to try to advocate for the release of that person shortly after being arrested. Time is really of the essence, so it's important to know that if you're going to call a CLIP and try to take advantage of this free legal resource to all Alameda County residents, regardless if you have a lawyer or not, because this would be an emergency service, it's accessible to all Alameda County residents. It's important to note that time is of the essence. So if you are recently arrested, it's important to call this number as soon as you can, A CLIP can dispatch a lawyer to try to advocate for your release in that moment in time. What a CLIP can also do is dispatch legal observers for site verification of ICE activity. A lot of times there are things on social media that end up being false reports of ICE in certain communities. But by calling a CLIP can dispatch observers to confirm whether or not ICE is in the area and be able to warn our communities about ICE presence in certain neighborhoods. A CLIP can also provide accompaniment to ICE check-ins. A lot of times folks may not realize that they may be in particularly vulnerable situations of detention by voluntarily presenting themselves to ICE check-ins. By calling a CLIP beforehand, you can check whether or not you may fall into a vulnerable category and whether it is worthwhile to have accompaniment by a lawyer or by a volunteer to your check-in. We've seen certainly that with lawyers who go to check-ins, it definitely mitigates the risk of being detained for folks who are checking in because they're required to, essentially, by ICE. And last thing a CLIP can do is provide trainings similar to the one you're listening to right now. So if you haven't written down that phone number, it's 510-241-4011. And please do start to memorize that. And next slide, please. And I will open it up for questions and Thank you so much for your time. Really appreciate it.
Thank you so much, Yosha. We do have a couple of questions that came in through the chat. I do want to say that if we do not get to your question during this segment, we will get to it later on in the presentation. So the first question is, I heard that in some cases, green cards are destroyed at the airport. When green card holders return to the US in such situations, who should I contact? Also, how should a green card holder deal with discrimination at the airport or in the country?
Yeah, these are great questions. I'm going to try to do my best to answer them. I've not heard of these particular situations, but what I would say, if your green card is destroyed at an airport, it's important, and you are at risk of being arrested and detained, it's important to, again, exercise your ability to be able to call a lawyer or call family in that moment to be able to see if you can have access to a legal resource to be able to vouch for your release. Also, again, important to call that a CLIP number, if nothing else, call that a CLIP number to see if a lawyer could be dispatched on the spot to try to advocate for your release. And if that's not possible, to see if they can work with you during the detention process. What was the second part of the question? I'm sorry.
No worries. The second part is, how should a green card holder deal with discrimination at the airport or in the country?
I think discrimination certainly should be raised. Again, you do have the right to remain silent, but it's important to know that if you can identify clear facts that you are being racially profiled, it may be worthwhile to break that silence to be able to put on alert to ICE and to put on alert to perhaps those around that discrimination is happening, that racial profiling is happening. And if that occurs, that could be grounds to, one, if you are detained, being able to say that your detention is unlawful because you were racially profiled. Being racially profiled is not grounds to be able to detain somebody or arrest somebody. And it may also be grounds to file a lawsuit later. So putting that in public, letting it be known that there is discrimination occurring may be worthwhile to be able to seek a remedy to be released later from detention or to be able to sue later. But again, it has to be weighed in people's particular situations. So if remaining silent is the best option at that moment to avoid getting into any further trouble, to avoid even preventing arrest and detention in the first place, that's probably what people should be doing.
Awesome, thank you so much. And then we also had another question. If I'm a US citizen, if I'm detained by ICE, what are my next steps?
You're a U.S. citizen detained by ICE. First of all, that is unlawful. No U.S. citizen should be detained by ICE. But of course, there are reports that that has happened. I've read those reports. So again, being able to communicate with family to then get in touch with representation would be the best way. Usually, if those quote unquote mistakes do happen, a person can usually be able to present evidence quickly enough that they should be released upon showing that they are a lawful United States citizen. So that's what I would say to that.
Alyosha, thank you so much for all the information you have provided to our community. Again, if you want to put the number to the rapid response hotline is 510-241-4011. And once again, thank you so much to the Centro Legal de la Raza for partnering with us again in this event. I will again review the information before our next presenter on how to access the Spanish channel. I will say it in English and I will do this quickly because we are running a little bit behind. So to hear the presentation in Spanish, you can click the globe icon at the bottom of the Zoom screen and select in Spanish. Para escuchar esta presentación en español, por favor haga clic en el icono del globo en la parte inferior de la pantalla de Zoom y seleccione español. Si tiene alguna pregunta, si no lo puede acceder el canal en español, me puede mandar un mensaje directo y yo le puedo ayudar. For our next presenter, we are so excited to partner with Oakland Privacy. And presenting for Oakland Privacy, we have Yadi Yunes, and she is a policy advocate. And translating for Yadi Yunes, we have Ivan Villanueva. He is part of our team. So thank you so much for being here, Yadi.
Hi, everyone. Great to be here with you. And I will try to touch on a couple of items on how to be safer online. And it will be pretty high level. So if there's specific questions, you can put them in the chat. So really briefly, I'll start off with giving a little bit of introduction, including Oakland Privacy. So if you can go to the next slide. So a little bit of Oakland Privacy. We're a statewide coalition that works on privacy, civil rights, and really establishing policies with local governments on protecting civil rights and putting guardrails around their use of technology. And I just want to say that when we talk about digital privacy, there are two different general buckets. One is the way that the government uses your data, and the other is on the consumer side and the way that private companies use your data. And unfortunately, there are instances such as with immigration enforcement and government surveillance where there is overlap between the government partnering with private companies to surveil and track what we do in our daily lives a little bit too much. Next slide. So I will start off by saying that while my presentation is going to give you advice and some tips on how you can better secure your data online, that this isn't a panacea. And if you take in all of the advice, it doesn't mean that you're going to be 100% protected. So I just want to be clear about that. But the measures that we give you will hopefully help you be more mindful of the information that you're putting in the digital world, and that can be used against you or your family or friends in a way that might not be readily apparent. So, there is the balance between privacy and safety and being able to just go on about our daily lives, and especially in this digital world where we want to engage, and we do have to engage with technology on all sorts of fronts. But really, privacy is becoming a safety issue for us. Next slide. So I'm going to talk about some ways that we can, a couple of different areas of ways that you can protect yourself online on different platforms, and the way that these technologies can be used not just by immigration, but by other entities. And we're going to focus on a couple of areas, which will be messaging, email, and browsing the web. But of course, there's many, many other ways that you can secure your information, but we're going to focus on the ones that are most frequently used by individuals. Next slide. So with text messaging and instant messaging, there are various platforms that you can use to send messages with your friends and loved ones. And there's a wide spectrum of these platforms and which are more secure. And again, not every platform is going to be secure, but some are definitely more secure than others. So you may be familiar with WhatsApp or WeChat, and if you weren't already aware, that platform was actually purchased by Meta, also known as Facebook. And while they do encrypt your messages, they do save the content of those messages, and if they can possibly hand them over to law enforcement, if law enforcement presents WhatsApp or Meta or Facebook with a warrant or a court order. So just be aware that if you're messaging on this platform, that it's not necessarily private and that they can be accessed by government. Alternative platform is Signal. It's a nonprofit, and it's a private messaging app that both encrypts your text and it also doesn't save your content. So what you need to do is you can create a username or use your phone number and add other people like you would on WhatsApp and WeChat, and that's a definitely more secure way of communicating through this app. And it's not tied, for example, to like a social media account. And so that's what we would recommend. And that way you can feel safer about the instant messages or text messages that you're communicating with your friends or loved ones will be more secure. Next slide. Email. I'm sure probably everybody in the room has an email account, and just like with text messaging platforms, there is a variety of email platforms that are more secure than others. And just like with text messaging, even though emails are encrypted, these companies can be compelled to share the information with law enforcement if law enforcement has a warrant for this information. So that is very important to keep in mind, that anything that you exchange via email could possibly be leaked or be seen by law enforcement if they have a warrant. There are platforms that are more secure that we recommend, such as Proton Mail, Tutanoa, and RiseUp. And what we suggest is to try to move away from the Google platform and Gmail, because that company is collecting the data and reading all of your emails, because a free service isn't actually free. And they use that information they collect on you to create a profile about you and sell that information to advertisers, and that's how they make the revenue. So it's not by providing you a free email account, but on selling it to marketers to then give you targeted advertising. So that is something to be aware of. Next slide. And then there's just generally doing searches on the web, online. There's a variety of platforms that you probably use to do online searches, and probably the most familiar is Google, because when we say we're doing an online search, we actually say you Google it. And again, Google is collecting every single keystroke, every search that you're making, and they're using that information to create a profile on you to then turn it to advertisers to make more targeted ads. So Google searches are free for us, but on the back end, they are making money off of our data. And there are alternative platforms that you can use that are more secure. And the two that we recommend are Brave and Firefox. And what these platforms do is that they will automatically block trackers for you. And this is really important because when you're doing searches on the web, you do have some consent over like the data that's being collected, especially as Californians. We have the right to opt out or the right to not have cookies. And that's a different conversation for a different day. And even when you're browsing, for example, on Google, on other platforms like Chrome or Edge, for example, if you're in incognito or private mode, it's been publicized that you're not actually browsing in private, in privacy and private mode. So our recommendations would be to use alternative browsing platforms altogether. And just like with the data that is collected by companies across the web, and your basically anything that you put online, this information can and is like shared with law enforcement. And so it's very important to be mindful of the searches that you're making and of the information that you're putting online. Next slide. Passwords. So I didn't touch on this earlier, but it's a good practice to ensure that you have strong and robust passwords and that you ensure that you're updating them and changing them pretty frequently. So we don't recommend having the same password for all of your user accounts and your important financial accounts and using the same password for a year or longer. Definitely not past a year. So our recommendations would be to have different passwords for different platforms. And if any banking or financial apps that you have, use different passwords for those. And to maybe set a calendar reminder to update those periodically and change them. And if, for example, you get an alert that your information may have been compromised by an entity that you use, that would be a good time to go in and update and refresh your passwords. There are platforms that can be used to help you manage your passwords because, of course, it's difficult to remember long, complex passwords for many, many accounts that we probably have. And so there are two services that we recommend that you can use are Bitwarden and ProtonPass. And those are free and they are really good servers for helping you manage and store your passwords. Next slide. Yes. So now we're getting a little bit into the nitty-gritty of the different kinds of data that is collected about you. It's not just like the keystrokes and the actual information that you're typing in chats and in your emails. But one very important aspect of that is location data. So on your phone, you do have the option to control the location data, both at the global level for your phone and then for the various apps that you use on your phone. And we highly recommend that you go in and check the settings of the location data and where possible, turn location data off. One of the things that advertisers / marketers do is try to get you to consent to having your location tracked automatically, and they kind of just try to get you to do that. And that is because the location, your location is very valuable. And again, they can make a better profile about you and better market to you. But again, that information can be shared with law enforcement. And so it's very, very important to try to minimize the location tracking as much as possible. So the way location tracking works is that every cell phone has a unique identifier, and that information is pinged to cell towers. So they can basically triangulate where you are to a pretty close distance. And so what we recommend is that if that app doesn't necessarily need you to have location data tracking on at all times in the background, to go ahead and turn that off, feature off. And there will be apps that try to force you to use it. For example, I tried to download the McDonald's app to get the cool coupons, and it was trying to force me to automatically have location data turned on at all times running in the background. And sometimes the app will break or it won't let you download the app if you don't consent to that. And so you have to make the decision of if it's worth having discounts at McDonald's or at a coffee shop for them to be tracking your data or tracking your location at all times. So, you can turn on location data while you're using an app, and you can have that setting. But we would say definitely try to not have an app tracking you at all times or running while the app is running in the background, because it's essentially tracking your patterns and your movements for where you are at all times of the day. And that is easy for whoever's accessing that information to create a profile of what your day looked like and what your movements are. And so they can find out where you live, where you work, who you visit, where you go worship, and the other places that you might visit. Next. Granting permissions. So just like with location data, you have the ability to grant applications different permissions to access a whole variety of information on your phone. And again, this is something that companies are trying to compel the user or the consumer to do automatically. And the thing to understand is that you don't have to give up that information necessarily, and it doesn't mean that you won't be able to use that application. So if an app, when you're downloading it, it requests to access your contacts, to let people know that you're on that particular app, you don't have to share your contact list, and we recommend that you don't do it. So these kinds of permissions are sometimes disguised as making your life easier and more convenient. And of course, you want to add your friends to that platform or your loved ones if they're on it, to find them or to also add them. But again, it's just creating a digital profile with more information about you and the people around you. And so just be mindful of the permissions that you're granting to different applications, and just try to ignore it or just decline granting those permissions unless absolutely necessary to use that app. And again, that's when you should think if it's worth it to be using that app. Next slide. Social media. A lot of us have social media accounts. And again, this is another place where you probably share a lot of information about your life and communicate with your friends and family. And even probably get your news or stay up to date on what's going on in the world. And social media tries to obtain a lot of information about you. When you're creating your profile, it asks for your name, your date of birth, to upload a picture. But again, all that is digital information, a digital profile that can be shared with law enforcement and law enforcement does go into these profiles when they're doing searches of particular people and known acquaintances, including but not limited to ICE. So if at all possible, you can set your social media to private or limit the information that you share, and what you put on your profile. And the same thing with your friends. You can ask them to not tag you, definitely not the location, and to be mindful of the kind of posts that you're putting on there, because what you might think is safe to speak about today may not be acceptable under a certain government climate in the future, and it can make you or other people a target. Next slide. And data brokers. So data brokers, if you're not familiar, is basically companies that operate like digital marketers, which collect a variety of data from us from different sources online, and includes things like our purchases, the activity that we do on social media, the permissions that we give on our phone from different applications. They bundle that information and they sell it to advertisers, or basically anyone who's willing to buy that information. So it's vast. And one of those potential buyers is law enforcement. And so again, when you're using all of these digital tools, you have to be mindful that that information can be collected and bundled and then shared with law enforcement. And the thing with privacy and digital security is that you may not feel or realize the impact of the searches that you're doing or the information that you're putting online in the moment. But when immigration comes knocking at your door or the door of a friend or family member, you may not know how it is that they found that person. And it might be the information that you're sharing online unwittingly and that you didn't realize was going to lead, for example, immigration people to come and find whoever it is that they're looking for that they decide to target. But there are ways, not only through minimizing the information that you share online, but in California, we have privacy laws and protections, and one of them is the right to opt out of the collection and the selling of our data by data brokers. And individually, you can go through different websites and say, like, do not sell my information, but that is extremely cumbersome, we understand. And there are platforms that can help you navigate that and get you off of these data broker lists in bulk. Some of them are Permission Slip, Delete Me, and Incogni. And we would recommend you look at those. I would highly recommend Permission Slip because it's by Consumer Reports, a very well-trusted nonprofit. And they've done a lot of work to help protect our data and help keep our data out of the hands of data brokers. Next slide. So as you saw, I touched on a variety of things very quickly and briefly. And again, I want to reiterate in closing that there are steps that you can take to minimize the information that can be used to track you and your family. And so we urge you to take these steps to secure your data online and just be more mindful of what you're sharing in the digital world. And, I just want to touch on a couple misconceptions. One is that some may say that you don't have, there's no like expectation of privacy or that your information is already out there. And both of those are not true. Privacy is safety, and every time you make a decision to share data or not, you are protecting your privacy. And I would say that privacy is a protection and upholding your civil rights, including the Fourth Amendment and the protection against warrantless searches and seizures. And in California, I'm glad to say that we are very big proponents of privacy and that the state is working very hard to give us even stronger privacy protections, including Senator Wahab. And there are other organizations that can help you with protecting those rights. So just remember that privacy and civil liberties are very intertwined and connected. And what I would say the takeaway is to try to implement some of these procedures for yourself, and also to talk about this information to your friends and family. And I know that there is a question of what can I do if you're an ally. And I would say one thing that you can do that would be very, very important is to raise the issue of privacy and civil liberties with your local government, your local council members, and to demand of them what they're doing to strengthen our civil liberties and what they're doing to protect our privacy. And especially if your local law enforcement uses tools for surveillance, how your local electeds are managing the information being collected and stored, and ensuring that it's not being weaponized against residents and being used, to surveil and literally, pick people off the street. And I just wanted to answer really quickly a question that was brought up earlier about your phone at the airport. And you don't have to give up your phone. However, law enforcement can just take your phone away. So the measure that we would say to protect yourself in that instance is to not use facial recognition to unlock your phone, and instead use a physical passcode, because law enforcement can hold up your phone to you and unlock it with Face ID, but they can't compel you to give up your passcode. And as the other question that was raised about, carrying your documents with you, California does not require that. And there have been instances where, people that are carrying identification with them, law enforcement can say that those are fake. And so that doesn't necessarily mean that you're going to be prevented from, getting questioned or, further accosted, unfortunately. So I will leave it at that. And if there's any questions, I'm happy to take them.
Thank you so much for your presentation, Yadi. We did check the chat, and actually, I think you covered most of the questions that the attendees had regarding the phones and privacy. Somebody did have a question regarding the usage of Firefox, but it was answered in the chat. So thank you so much, Yadi and Open Privacy, for providing this very valuable information to our attendees. And we hope to have you on in a future event as well. For our last presentation, we will also, yes, I will be reviewing the how to access these information in Spanish once again. We are close to ending this event, so we only have one more presenter, which we're really excited about as well. So to hear this presentation in Spanish, please click the globe icon at the bottom of the screen and select Spanish. Para escuchar la presentación en español, por favor haga clic en el icono del globo de la parte inferior de la pantalla de Zoom y seleccione el idioma español. For our last presenter, we have the Immigration Resource Legal Center, and presenting for them will be Carolina Castañeda, who is a staff attorney and legal trainer. And doing the presentation in Spanish will also be Veronica Garcia. Thank you so much for being here, Carolina.
Thank you so much, Astrid, and special thanks to Senator Wahab and staff for having us here today. Like Astrid said, my name is Carolina Castañeda, and I am a staff attorney at the Immigrant Legal Resource Center. My colleague, Veronica Garcia, also a senior staff attorney at the LRC, is doing the Spanish translation for us. Next slide, please. For our portion today, we're going to discuss birthright citizenship. I knew it's been in the news the last couple of days. Expanded expedited removal and mandatory detention. We're going to try to do the presentation for approximately 15 minutes to then leave space for Q&A. Next slide, please. So we're going to start with birthright citizenship. As you may recall, on the first day of his administration on January 20th, which seems like a long time ago to some of us, President Trump issued an executive order on birthright citizenship, an order that is clearly unconstitutional, and many district court judges have found it so. The very next day after the executive order was issued, the first lawsuit against it was filed. Then a couple of days later, on February 5th, a district court judge issued a nationwide preliminary injunction blocking the executive order from going into effect nationwide. The government appealed the issuance of the nationwide injunction, and that is the issue that made its way to the Supreme Court. Next slide, please. To emphasize, the Supreme Court did not issue a decision on birthright citizenship. They only issued a decision holding that district court judges cannot issue nationwide injunctions. That was the extent of what was litigated at the Supreme Court. So for now, for the next 30 days from the date of the Supreme Court decision, the birthright citizenship executive order cannot go into effect. It cannot go into effect until after July 27th, and whether it actually goes into effect, it's still up in the air. There have already been lawsuits filed against it, and we expect that those lawsuits will be successful. What this means for us all is that the issue on birthright citizenship for now can vary depending on where a baby is born. We could potentially have a baby born in August in California to parents without status who is a U.S. citizen by birth, as written in the Constitution, while a baby born in Texas, for example, on the same day to parents without status may not be a U.S. citizen by birth. I want to emphasize again that the lower courts that have heard the lawsuits on the merits have found that this executive order is blatantly unconstitutional. However, in the meantime, as those cases progress, affected babies could be denied Social Security cards and passports, which will make it nearly impossible for them to access essential services, such as healthcare and food programs. In one of those pending cases, the judge asked the government to submit a statement by today on whether the government thinks it can start removing children from the United States who are subject to the terms of the executive order and who are not part of the lawsuits. The ILRC and many of our partner orgs, some of them which are on the call today, will continue to monitor birthright citizenship and will continue to provide updates as they become available. Next slide, please. Now I'm going to shift gears and talk about expedited removal, which is a key reason why we are seeing so many courthouse arrests and why the government is actively terminating parole programs. Expedited removal is the process that is used to deport people quickly, just as the name suggests. People subject to expedited removal do not have an opportunity to have a hearing before a judge or the right to speak to an attorney before being deported. They are detained until they are deported and cannot apply for relief before the court, with a limited exception for those who expressed a fear of returning to their country of origin. Next slide, please. So I want to discuss how the expedited process applied prior to this administration because it helps us understand how the new expanded process targets many more people. So expedited removal as we knew it before this administration for many, many years applied at or near a port of entry, such as the borders with Mexico or Canada and airports. If someone was apprehended by immigration authorities within 100 miles of a border, whether by land or sea, and within 14 days of their entry, then they would be subject to this process. They could be removed without a hearing before an immigration judge and without speaking to an attorney. So if apprehended only within 100 miles of a border and they had not been here for 14 days, that was expedited removal as we knew it before this administration. Um, Next slide, please. Now, under this administration, expedited removal has been expanded. Now, expedited removal applies to anyone living anywhere in the United States. So remember that previously it only applied within 100 miles of the border. Now it applies anywhere, everywhere within the United States. The time for being present in the US has also drastically increased. Before, if someone was apprehended within 100 miles of the border and within 14 days, they would be subject to expedited removal. Now, if they're apprehended anywhere in the United States and they cannot prove that they have been in the United States for 2 years or more, they are subject to expedited removal. And then to make things a little bit more complicated, the wording says that 2 years or more from the date of an inadmissibility determination. So the government is interpreting this to mean that if someone was initially apprehended by immigration authorities when they first entered the country, whether they entered without inspection or maybe presented themselves at a border seeking asylum and were paroled, that the 2 years counts from that apprehension. So it also affects people who were paroled, but the government then revokes their parole and they have not been present in the US for 2 years when they were granted that parole. So now, as we know it under this administration, expedited removal applies anywhere in the US to those who entered without inspection and have not been in the US for 2 years or more when they were encountered by immigration authorities, and to those whose parole period has been revoked by the government. Next slide, please. Expedited removal does not apply to those who entered with a valid visa or other valid documentation, to those who entered without documents, so entered without inspection, have been in the US for 2 years or more, and were not apprehended by immigration authorities within that initial 2-year period of having entered the US. It also doesn't apply to those who are afraid of returning to their country. Next slide. So the expedited removal expansion is key to why we're seeing court arrests now. Right now, the government or ICE is actively targeting those who have been in the US for less than 2 years. What we're seeing in court is that the government is asking the court to dismiss their cases so that they are no longer in proceedings with the immigration court. This dismissal is not the same as it was under an Obama or a Biden administration. This dismissal is just so the government can then immediately arrest the person once the judge dismisses their case and put them in the expedited removal process, where they have no right to a hearing before a judge and no right to an attorney. We've also seen that some people are being arrested even if the judge does not dismiss their case. So why is this happening? Basically, this allows the government to have two bites at the apple. If the judge does not dismiss their case, they put the person in detention and force the court to transfer their hearing from a non-detained docket to a court where a judge litigates cases of people who are detained. And the hope is that that judge might rule in favor of the government in dismissing the case. They're also banking on people not wanting to be in detention, which of course no one wants to be in detention, and then they're banking on them taking an order of removal. The government says that people should self-deport to avoid this, but I just want to remind everyone and emphasize that self-deportation is a myth that was created by this administration. Next slide, please. So let's go ahead and try with an example. Let's say that Daniela entered without inspection in December of 2020 through the California desert. Within hours of entering without inspection, she was apprehended by immigration authorities, released from custody, and placed in removal proceedings before the immigration court. So when she was apprehended, she was immediately referred to the immigration court to fight her case in court. Daniela now has a court hearing next month at the San Francisco Immigration Court, and she is worried about being arrested. So should Daniela be worried? Does the expanded expedited removal process apply to her? Unfortunately, it does. Daniela is at risk because in December of 2020, when she was first apprehended by immigration authorities after entering without inspection, at that point, she didn't have the 2 years of presence in the United States. So even though now she's been in the country over 4 years, at the time that she was apprehended in December of 2020, she didn't have those 2 years yet. There's also, so there is the risk that in court, the government could move to dismiss her case. Though from what we are hearing right now, it seems that the government is targeting those who entered within the last 2 years, but this could change. So Daniela still runs that risk that the government could move to dismiss her case. So if the government asks the judge to dismiss her case, Daniela will have to fight against this. The government asking the court to dismiss her case would be doing so just so that they can place her in the expedited removal process, preventing her from a hearing before the court and from having an attorney. She can object to the government's motion, ask the court to give her additional time to consult with an attorney or to hire an attorney if she doesn't have one, and to allow her to have her day in court. She should also highlight any pending applications for relief and her fear of return if she has one. But ultimately, the judge will decide whether they grant the government's motion. And then to complicate things more, Daniela may also be subject to mandatory detention, which is being detained without the possibility of a bond. And we'll talk about this in a moment. But as you can see, expanded expedited removal is terrible. People who are doing everything right, seeking asylum, showing up to their court, complying with their ICE check-ins, could still be arrested and possibly detained without a bond. Next slide, please. Under this administration, we've also seen an increase in categories of people who would be subject to being detained without being eligible for bond. They're detained until their case, either they win the case or until they are removed from the country. The Laken Riley Act was signed into law on January 29th. Under this act, anyone who has merely been arrested or charged with certain offenses, including shoplifting, burglary, and assaulting a law enforcement officer, for example, are subject to mandatory detention. So they would be detained without the possibility of a bond. And the scary part here is that a conviction is not required. A mere arrest will suffice. And unfortunately, we know that our law enforcement system is designed to overcharge. Many charges ultimately end up being dismissed in court, but this means that many will be subject to mandatory detention, even though they are not convicted of these offenses. Then recently, the Board of Immigration Appeals issued a decision finding that people who entered the United States without proper authorization documents and were arrested by immigration authorities shortly after entering the US are also subject to mandatory detention. So this is so even if they were released by immigration authorities like Daniela in our hypo and are detained now. So for example, Daniela could be subject to mandatory detention if her case is dismissed. The government can put her into the expedited removal process, which makes detention mandatory. But if her case is not dismissed, the government could still detain her and she would be subject to mandatory detention under this case because she was initially arrested by immigration authorities in December of 2020 when she first entered the US without authorization. So as you can see, all these changes have a chilling effect on our community. People are scared, and rightfully so, to continue complying because even if they comply and they do everything they're instructed to do, they may end up in detention, including many who have been unjustly detained in the countries that they are fleeing from. It's also very difficult for people who have court hearings and for immigration attorneys. Those in court must attend their hearings, else they can be ordered removed or deported for not showing up. But if they show up, the court could dismiss their case and they could be arrested. Or even if the court does not dismiss their case, the government can still arrest them. So we know this is very emotionally tolling information, but it's very important that we all know what is happening. I know we have a couple of minutes left for questions, so I'll go ahead and open it up for any questions that anyone might have.
Thank you so much for all the information, Carolina. Yeah, I do want to remind folks, we are a little bit past date, but if you do have any last minute questions, please use the Q&A feature to ask Carolina some questions. We do have one from one of the attendees, and it says, am I required to always bring my green card, passport, and other documents? Am I required or compelled by law to show immigration documents to ICE or police in case they ask for it? I normally do not bring it, for it might get lost, and I'm here legally. Thanks.
You are not compelled to show them if, for example, stopped in the streets by, let's say, an ICE officer. You can assert your right to remain silent. However, there is also a law that says that if you're a legal permanent resident, you should be carrying your green card with you. We know how expensive it is to replace a green card if it gets lost. So at a minimum, we do recommend that you carry a copy of it.
Awesome. That was one of the only pending questions. Let me check once again to make sure that all the questions on the chat were answered. I think we answered the question, but if I'm a US citizen and I'm detained by ICE, what are the next steps?
So then at that, if it's a US citizen who is detained by ICE, I would strongly recommend that they contact a civil litigation attorney, because you do have the right to sue the government for being unjustly detained as a US citizen.
Awesome. Well, there doesn't seem to be any more questions. However, if for those who are still part of the event, if you do have any last minute questions, please make sure to use the Q&A feature, and we're more than happy to share those questions with our wonderful panelists and then get the answer to you if you're unable to do that right now. Once again, I would like to thank each one of our panelists. We had ACLU, we had Luis present for ACLU, so thank you so much for being here. We also had a presentation by Centro Legal de la Raza. Alyosha, he actually had to take off to another commitment, but thank you so much, Centro Legal, for being here and being part of this event, as well as Oakland Privacy. I actually myself learned so much from the presentation that Yavi did. So thank you so much, Yavi, for answering some questions that we also had. And lastly, thank you so much to Carolina and Veronica from Immigration Resource Legal Center for being part of this presentation and providing all that valuable information to the attendees. Once again, I'd like to leave everyone with the contact information for our office. My name is Astrid Scott, and I work for the office of State Senator Dr. Aisha Wahab. Her district covers Hayward all the way down to Sunnyvale. And if you are familiar with her, she is somebody who advocates for communities of color, for women, for children. And she really wanted us to organize this event to get information to the people who need this information from her district. So once again, our phone number is 510-794-3900. Thank you so much, everyone, for being here, part of this event. You can find our social media on Facebook and Instagram. And if you guys have any questions, you can email senator.wahab@senate.ca.gov, but we have also provided our personal email addresses on the chat. So thank you so much, everyone. Okay, I think we had one more question. Do you want to take it, Carolina?
Yeah, that's fine.
Okay, what is happening with the people who already are citizens and the administration? I think maybe you touched on this, and the administration wants to cancel it.
So there is a push for denaturalization, but that is something that is very hard to do. The administration hasn't really said how they're gonna plan to go about trying to denats people. So I would say we shouldn't panic. It's something that they're saying they're gonna do. Whether they can actually do it is gonna be much more complicated than they make it seem. So if you're a US citizen, I wouldn't be too concerned about it until we learn more, but it's not something that they can just do because they want to do from one day to the next.
Thank you so much for answering that last question. Again, everyone, thank you so much for being here. Please reach out to our office if you need a copy of the slides or any of the information that was shared today. And wishing everybody a safe and good evening. Thank you so much for being here.